If you are married, does your wife or your husband have to file bankruptcy with you when you file bankruptcy in Nebraska? The answer to that question is no. If you're a married person, your spouse is not required to file bankruptcy with you. You may file yourself. Now, if you're married and living together, however, it does impact the case. When the court looks at whether you qualify for bankruptcy, especially Chapter 7, where there are limits as to what your income can be, they do look at the total household income. So the court will look at your paychecks and your spouse's paychecks for the past 6 months, and they want to see 2 years of your income tax returns. So you can file without your spouse, but the income of the household is considered. We do not list your spouse's name or social security numbers when we file the case for you. However, if your spouse has co-signed debts with you, which is somewhat common, then your spouse does have to receive a notice of the bankruptcy filing. Now, generally speaking, your debts are your debts and your spouse's debts are his or hers, and you're not responsible for your spouse's debts unless they are considered to be necessities of life, typically medical debts. In those cases, if you have a lot of medical debts and they come in your name and not your spouse's names, and if you file bankruptcy, you need to understand the creditors can go after your spouse for any type of a medical debt or necessity of life. That sometimes happens and sometimes not. It's hard to say. It varies a lot from case to case. But going back to the original issue, does your spouse have to file bankruptcy? No. You can be married. You have to report their income, but they do not have to be a party to this case at all. If you have questions about debts and marital debts and bankruptcy, please call us at the number below. We answer these questions every day. We offer a free consultation, and we would love to talk to you. Thank you for watching.